Alexa, stop it. God, embarrassing, starting off with some really cheesy jump up. I just put like the prompt in, I just said, play me some drum and bass, and it kind of takes you through to this shit radio station that plays you generic kind of like gold dust coming through your speakers, you know, happy, clappy, candy raver bullshit that like, I'm not a connoisseur of drum and bass anymore, you know, I just sort of like listen to Neuro, mate, do you know what I mean? Like, I'm just one of those kind of like middle of the road, kind of like burger eating, sort of like super dry hoodie wearing drum and bass fans. I'm not even a drum and bass fan. I haven't been clubbing in over a year. I've been in fucking hospital. I went to a hospital in London, right? In the beginning of 2023. I had a bit of a breakdown in Costa Coffee, and I ended up getting sectioned from there, taken to the place of safety. They kept me there for like about a week, and like they had this solicitor or a legal woman came in, told me that I was going to be subject to an unauthorised deprivation of liberty. Sorry, an authorised deprivation of liberty, which is sort of a contradiction in terms, really. Anyway, I was there for a bit, and then they sent me to a PICU, which stands for PICU. It's Psychiatric Intensive Care Unit in London, in Blackheath. Tyler Ward, it was called. And when I was there, I broke my hand. There was a nurse there. I won't name her. She's got the same name as somebody else that, she's got the same name as my sister, basically, but I won't name her. And she sort of really pissed me off in what she was saying. They were giving me, I still got them in this box, so like I could probably dig them out if I really wanted to. I'm not going to. They gave me my section papers, but they redacted them in a way that meant that they were useless for me to be able to get any sort of medical jurisprudence adherence or policy adherence. So they said, you can have them, you can have your section papers, you can't have your medical legal scrutiny checklist, which just Google that, is like not cricket, but you can have the section papers. So what we're going to do is either we're going to redact the names of the AMPs, approved mental health professionals who completed the section, or we're going to redact what they said about you. And they said shit about explosives, like I had explosives on me, and like made some really kind of, what it said, you could see why they like wanted it redacted. Like some of it was accurate, some of it was like broadly, you know, good. And you know, I wasn't in a good mental state. I was pretty head fucked at that point. But the point is, I broke my hand, right, and I got this boxer's fracture. I don't know if you can see, there's a slight swelling on the left-hand side. If you look on my Instagram, you can see the X-ray photos. And it was guys in St Thomas Hospital I went to, and they just were like totally streamlined me through there, like kind of VIP negligence pathway. So I got there. First of all, the staff member who'd escorted me wrote down the wrong section, said that I was on a section 3 when I was on a section 2, and then spelt my name wrong, kind of like accidentally on purpose, which like could have been an accident, but I don't think it was. And then I was waiting in sort of reception for a bit, and then they said go through to X-ray, but they didn't. Normally, if you're going to go through to X-ray, I think they give you a bit of paper with a referral, and it's got like a barcode on it, and you have to present that referral letter to X-ray. I don't know this at all, it's a total assumption. If I'm wrong, let me know in the comments, but they just told me to go to X-ray, follow the lines on the floor, go to X-ray. When I got to X-ray, they started asking me for all my personal details. I filmed this on my phone because I thought it was really suspect. They started asking me for my photo ID, my name, my address, like reeling off all the things that you would say. You know, I was suspicious at the time. I thought they were trying to record me, like, you know. Anyway, I kind of had this X-ray done, and I'd broken my hand. I punched a window in the office. I just punched this window really hard, and I just instantly smashed the fucking bone in the outside of my little finger, handy bit. And the X-ray showed it was broken. Put me together like a moulded plastic cast thing, and I went back to the hospital with a referral letter that was like written on the back of a fag packet. Like she got like a little. Oh, I have already cancelled my Ancestry membership. It's like 50 quid a month after 3 months, which is shit. Did a DNA test the other day. If anyone wants to see if you're related to me, you can do a DNA test too. I've done one with Ancestry. Let me know about that. If you want to link up on Ancestry, link me in the comments if you want to find out if you're my brother or sister or my son or daughter. Anyway, Home Office. This has got my old passport in it. I won't show that. Just had my new passport issued. She wrote down when you're supposed to get an adult discharge summary. This I am sure of. You're supposed, if you break a bone, you go to orthopedic, and you have an X-ray and you've got a broken bone. I had to have it broken and reset, the way they like kind of manipulated it around, which hurt like fuck. And they kind of just said, yeah, that'll do. Put your arm in a sling. They put a cast on me, and eventually the cast came off and it got replaced by like a moulded plastic blue thing. But they never asked me, like, were you involved in any violent altercation? Like, if someone's broken their hand, it's like, what if I'd broken my hand on someone's head? Or on, like, a car window when I was about to steal their car? Or, like, what if... Do you know, it was like, I've obviously been punching something. And they said I'm in a psychiatric ward, and I guess that they didn't ask the psychiatric staff anything. Like all the psychiatric staff did was try to stop me recording the consultation where I was explaining what was going on. It's still on YouTube. Scroll back through my videos and you can see the ones from Guy's and St Thomas Hospital in 2023 when I was in Tyler Ward, Signet Blackheath. And I was thinking about what the kind of jurisdictional duty is of doctors and healthcare professionals to ask those kind of questions. To say if someone comes into A&E, with an ear missing, covered in blood after a night out, do they say, like a seagull pecked it off, mate? Just, and if they're given like a horse shit narrative that the person doesn't really believe, that nobody would really believe, where do we stand on that? Like, they didn't ask me any questions about whether I've been in a violent altercation, whether I was assaulted. I was assaulted at that hospital, actually. I was assaulted by a man who I provoked, in fairness. But yeah, I provoked this man who I believed had just done something criminal. And he got really aggressive with me and punched me in the head a couple of times. And it got split up by staff. And I went to the office the next day and asked them about it. And they were just all like stonewalled me, just ghosted me, aired me. And they was just like, yeah, I got punched yesterday. Is it on the CCTV? Like, what should I do about it? And they were just like, nope, no, I didn't. Nope. And that was that. But let's just, I can hear footsteps on the stairs and they're going to come in and do my obs. I'll have to pause it. Now we're good. Right, so I asked Gemini a bit more about this kind of thing, and that's what this video is about today, is the jurisdictional responsibility of healthcare staff who perform sort of complex surgeries on people to report the suspicious nature. Yeah, I mean, I think that's quite relevant, So I said, as persons sworn to a Hippocratic oath, is there an implicit duty to report injuries regarding surgery or of a particularly graphic nature to the authorities in the UK and US if they seem suspicious? So, for example, if a patient had dismembered and eaten every finger but claimed they did it totally by accident making a salad, or a Chelsea smile had said to be a shaving injury, or a patient who presented with cannibal rapist scum carved into their chest, which they told the doctor was self-inflicted, should a consultant, nurse or doctor be duty-bound to report it on the basis they have reasonable grounds for suspicion? Also, from a security services perspective, if a surveillance operation is already in place and a hospital admission occurs involving a known victim of the criminals whose actions are being monitored, where does civil, criminal and medical data protection laws stand when organisations like Interpol, Europol, NCA, FBI, CIA, NSA or police making direct or perhaps covert intervention with healthcare professionals to obtain valuable evidence? What about legislation revolving around surveillance operations? Do they have to act to gather evidence which is deemed vital to preserve life? Could either NHS or private medical staff who fail to make preliminary statements of serious injuries with broadly agreeable circumspect circumstances provided face legal action? And would this also apply to intelligence or security services neglecting to or refusing to approach healthcare professionals' data protection departments to review medical evidence in that they could be held culpable? I'm considering just letting Gemini read it for you. It sounded all right yesterday. I thought it was going to feed back through the mic, but it didn't. Shall I just...
This is a complex area involving medical ethics, legal obligations, and data protection, with distinctions between the UK and US. Implicit duty to report suspicious injuries, UK and US. General principle. While the Hippocratic Oath emphasizes patient confidentiality, both the UK and US have established legal and ethical frameworks that create an implicit and often explicit duty for healthcare professionals to report certain suspicious injuries, especially when there are reasonable grounds for suspicion of abuse, neglect, or serious crime. This duty often overrides patient confidentiality in specific circumstances, particularly when there's a risk of harm to the patient or others. Specific examples provided: dismembered and eaten fingers claimed as a salad accident, or Chelsea smile claimed as a shaving injury. These scenarios, given their extremely unusual and severe nature, would undoubtedly trigger a strong suspicion of harm, self-inflicted or otherwise, and potentially linked to criminal activity or severe mental health issues. Healthcare professionals in both the UK and US would have a professional and likely legal duty to consider reporting these to the appropriate authorities, e.g. police, adult social services/safeguarding teams. The claim of accident would be highly unlikely to be accepted at face value given the severity and specific nature of the injuries. Cannibal rapist scum carved into chest, claimed as self-inflicted. This is another highly graphic and suspicious injury. While the patient's claim of self-infliction would be noted, the nature of the carving strongly suggests a context of violence, coercion, or severe mental distress. Again, reporting to authorities would be highly probable and likely legally mandated, especially if there's any indication of a wider threat or ongoing abuse. Legal basis for reporting. UK. Safeguarding. The overarching principle is safeguarding. Healthcare professionals have a duty to safeguard children and vulnerable adults. This includes reporting suspected child abuse or neglect, and suspected abuse or neglect of adults who lack capacity or are at risk of serious harm. The General Medical Council (GMC) guidance supports disclosure in the public interest, especially for serious crime, even without consent, if it's proportionate and necessary. Public interest. Disclosure may be justified in the public interest, where the harm to the public or to the patient is considered to outweigh the public interest in maintaining confidentiality. This often applies to serious crimes, specific legislation. While there isn't one single duty to report all Suspicious Injuries Act, various pieces of legislation and professional guidance, e.g. from the GMC, Nursing and Midwifery Council (CQC) and local safeguarding boards, provide the framework. Failure to report in certain circumstances, e.g. child abuse, can lead to disciplinary action and potentially criminal charges. US. Mandatory reporting laws. Most US states have mandatory reporting laws that require healthcare professionals to report suspected child abuse, elder abuse, and sometimes domestic violence. Many states also require reporting of specific injuries like gunshot wounds, stab wounds, or other injuries resulting from violent acts. Vulnerable populations. The focus is heavily on protecting vulnerable populations. Vary by state. It's crucial to note that mandatory reporting laws vary significantly from state to state. Healthcare professionals must be aware of the specific laws in their jurisdiction. Professional ethics. Professional bodies like the AMA also have ethical guidelines that balance confidentiality with the need to protect patients and the public. Reasonable grounds for suspicion. The key phrase is reasonable grounds for suspicion. This doesn't mean absolute certainty. If the circumstances of the injury are inconsistent with the patient's explanation, or if there are other indicators of abuse, neglect, or criminal activity, healthcare professionals are generally expected to report. Security services and hospital admissions, data protection and evidence gathering. This is a highly sensitive area where national security interests intersect with individual rights to privacy and medical confidentiality. General principles. Medical confidentiality, GDPR, DPA in UK, HIPAA in US. Healthcare data is highly protected. Generally, law enforcement or intelligence agencies cannot simply demand medical records without a legal basis. Legal gateway. There must be a legal gateway for disclosure. This typically involves court order, FANREF warrant. A court order or warrant is usually required to compel disclosure of medical records. This demonstrates judicial oversight and ensures the request is proportionate and necessary. Statutory powers. Specific legislation may grant certain agencies powers to obtain information in defined circumstances, e.g., for national security, serious crime prevention. Vital interests, public interest. In very limited circumstances, disclosure might be justified to protect vital interests, life-threatening situations, or in the overriding public interest, e.g., preventing terrorism or serious harm. However, this is usually a high bar. Consent. Patient consent is the primary basis for sharing, but in these scenarios, it's often not feasible or appropriate. Organizations like Interpol, Europol, NCA, FBI, CIA, NSA, or police. Police/NCA UK/FBI US. These are domestic law enforcement agencies. They would typically follow established legal processes, e.g., obtaining a court order, to request medical information from healthcare providers. Interpol/Europol. These are international cooperation bodies. They don't have direct powers to compel disclosure from national healthcare providers. They would typically work through the national law enforcement agencies, e.g., NCA in the UK, to make requests, which would then be subject to the national legal frameworks. CIA, NSA US/MI5, MI6 UK. These are intelligence agencies. Their powers to access data, including medical data, are governed by specific intelligence legislation, e.g., Investigatory Powers Act 2016 in the UK, various statutes in the US. These powers are usually tightly controlled and subject to oversight due to the highly sensitive nature of their work. They would generally need to demonstrate a strong national security justification and obtain appropriate authorization, e.g., a warrant from a judicial commissioner. Direct or covert intervention with healthcare professionals. Direct intervention. Law enforcement might directly approach healthcare professionals with a court order or legal request. Covert intervention. Covert intervention to obtain medical evidence is highly regulated and would only be permitted under very specific and exceptional circumstances, usually requiring a high-level judicial authorization or warrant. This is because it heavily impacts privacy rights. It would need to be demonstrably necessary and proportionate to a serious threat. Legislation revolving around surveillance operations and vital evidence. UK. Investigatory Powers Act 2016, IPA. This is the primary legislation governing the powers of intelligence agencies and law enforcement to intercept communications, acquire communications data, and conduct targeted surveillance, including access to bulk personal datasets. It sets out strict conditions for obtaining warrants and authorizations, including for accessing sensitive data like health information. Data Protection Act 2018, DPA, and UK GDPR. These provide the general framework for data protection. While there are exemptions for law enforcement and national security, these exemptions must be applied lawfully and proportionately. Human Rights Act 1998 incorporates Article 8 of the European Convention on Human Rights, right to private and family life, which requires any interference with privacy to be lawful, necessary, and proportionate. U.S. Fourth Amendment protects against unreasonable searches and seizures, requiring warrants based on probable cause for many types of surveillance and data acquisition. Electronic Communications Privacy Act, ECPA, regulates access to electronic communications. Foreign Intelligence Surveillance Act, FISA, governs intelligence collection targeting foreign powers or agents of foreign powers, including procedures for obtaining warrants from the Foreign Intelligence Surveillance Court, FISC. HIPAA sets standards for the privacy of protected health information, PHI. While it has provisions for law enforcement, these generally require a court order, warrant, or subpoena. Duty to act to gather evidence deemed vital to preserve life. Yes, in both the UK and US, there are provisions that allow for the expedited gathering of vital evidence, including medical information, when there is an immediate threat to life or a risk of serious harm. This falls under concepts like vital interests, GDPR-DPA, or emergency circumstances. However, even in such urgent situations, there is usually a requirement for retrospective authorization or a clear legal basis. The actions taken must be proportionate to the threat. For example, if a patient is admitted who is a known victim of a criminal group under surveillance, and their injuries are clearly linked to that group's activities, and there is an imminent threat to their life or the lives of others, law enforcement or intelligence agencies might seek expedited access to relevant medical information to prevent further harm. Legal action for failure to act. NHS or private medical staff failing to make preliminary statements for serious injuries with broadly agreeable circumstances. Yes, they could face legal action. Professional misconduct. Failure to adhere to safeguarding policies and mandatory reporting duties can lead to disciplinary action by their professional bodies, e.g., GMC, NMC in the UK, state licensing boards in the US, potentially resulting in suspension or loss of license. Civil liability. If a patient suffers further harm as a direct result of a healthcare professional's failure to report suspected abuse or neglect, they could potentially face civil lawsuits for negligence. Criminal charges. In egregious cases, particularly involving child abuse or severe neglect, a failure to report where there was a clear legal duty could lead to criminal charges, e.g., misprision of felony in some jurisdictions, or specific charges related to child endangerment. The broadly agreeable circumstances part is key. If the circumstances are truly benign and the injury is genuinely accidental, there's no duty to report. But if there are reasonable grounds for suspicion that the explanation is false, or that abuse/crime has occurred, then the duty arises. Intelligence or security services neglecting or refusing to approach healthcare professionals' data protection departments to review medical evidence. Yes, they could be held culpable. Intelligence and security services are generally subject to legal frameworks that govern their data access and surveillance activities. Legal challenges. If they unlawfully access medical data without proper authorization, e.g., a warrant or statutory power, they could face legal challenges from individuals, e.g., under human rights legislation, data protection laws. Internal disciplinary action. There would likely be internal disciplinary consequences for failing to follow established legal procedures. Oversight bodies. In the UK, bodies like the Investigatory Powers Commissioner's Office, IPCO, oversee the activities of intelligence agencies. In the US, there are various oversight mechanisms, including congressional committees and inspector generals. These bodies could investigate and hold agencies accountable for unlawful conduct. Public trust. Unlawful access to highly sensitive medical data would severely damage public trust in these organizations, which is crucial for their effectiveness. Therefore, there's a strong incentive for them to operate within the law. In summary, while patient confidentiality is paramount, it is not absolute. When serious suspicious injuries are encountered, healthcare professionals have clear ethical and often legal duties to report, particularly when vulnerable individuals are involved or serious crime is suspected. Intelligence and security services also operate under strict legal frameworks for accessing sensitive data like medical records, and their actions are subject to oversight and potential legal challenge if those frameworks are breached.
So, that's the lowdown on that. I mean, don't take this the wrong way. I'm not, this isn't like a kind of a slight at the NHS or a threat to anybody who might be a cannibal. I don't have anything against, well, I guess I do have something against cannibals a bit, but I'm not going to carve anyone's chest up, and obviously that's just like a hypothetical example. This Guy's and St Thomas thing, like, yeah, they just gave me like a phone number. They just wrote down with a pen and paper on the back of this bit of paper, like, ring up in 6 weeks and tell us if your hand still really fucking hurts and if your bones are permanently malformed or not. You know, they didn't give me an adult discharge summary. They didn't give me an x-ray referral letter. And yeah, it was just like, they didn't question me on whether there'd been a violent altercation or whether I'd hurt anybody, you know, in the process of hurting myself. I wasn't trying to harm the lady either. Like, I punched a window, but I was super stupid because it was a PQ and all the windows are like these windows. there's these Trident windows which are like bulletproof glass. You hit it with a £40 sledge, you wouldn't break one of those, man. Like it's like, yeah, it was like the sliding window, and I wasn't trying to break the window. I don't know what I was trying to do. I very rarely lose my temper. I did hit it as hard as I could, and I just could see straight away. You know, it snapped like a fucking pencil, and yeah, they just gave me this kind of like, I had Teams consultations when I moved to Colchester, Essex, Signet in 2023. Had some Teams consultations from people saying, "How's your hand? Is it okay?" Yeah, but it's all right. But yeah, I mean, in organised crime and kind of situations where they've already got a surveillance operation in place, if they just go and get the medical evidence of the person that's, you know, just been hurt, then they can just bang on the door and prosecute the people who probably did it, can't they? Do you know what I mean? It's like I mean, obviously, if people, it depends on, you know, if you've got like a hostage situation, that might not be possible. But I'm not a terrorist or, well, I mean, I don't know how to explain my situation broadly. I just want to say, sorry to anybody who's been offended by this video, and then by any of my videos. And I just want to say that although I'm sort of glibly and ambivalently talking about crime and punishment and security infrastructures and narratives of legislation, I haven't forgotten about the harrowing situation in Gaza. And I'd implore everybody, I've been just kind of sharing every story I can onto my story. I'll be donating generously. Maybe that's fucking pointless, but I will be donating, and I think everybody should do as well. I think it's good to see that the government are sitting up a bit, taking notice, and I hope that the situation gets better soon, and without prejudice to anyone or anything that might have happened. I hope that the future is peaceful and calm, collaborative, and that everybody that wants a lasting peace in society and in the world manages to achieve those goals in mutual reciprocity and not in conflict and dissection of emotion and vengeance and dogmatic specifications of anger, because we need more love in the world, don't we, and not more anger. And I don't know if I'm the person to, if I'm the man for the job to give everyone more love. I'm living a pretty loveless existence. I love quite a lot of people. I saw a great quote, I'll leave you with this great quote this morning on the internet. It said, you don't love her because she's beautiful, but she's beautiful because you love her. And I'll leave you with that.